Thank you for joining us for part 3 of our special education pro bono training. We're going to discuss the due process hearing today. We're also going to have some time to talk about the impact of practicing during the pandemic and what that has meant for special education cases in particular. I'm Jen Massey, the pro bono director at Children's Law Center. I'll tell you a little bit about our pro bono program today. Overall, our virtual training series, about today's training, as well as on-demand resources and where you can find them. So Children's Law Center fights so each child in DC can grow up with a loving family, good health, and a quality education. We are serving over 5,000 children and families each year, and we do that with the assistance of pro bono lawyers who are critical to helping us reach that far into the community, helping that we serve and who are coming to us. And families are turning to us for assistance in the areas of family health and education. We're here to specifically focus on special education, but there are other areas of work that fall in family and health as well. We support our pro bono attorneys throughout the case. We're doing it on the front end when we screen the cases and the legal issues to ensure they're appropriate for placement with a lawyer who may not have experience doing this. And we have trainings like today's and others that we post on our website. So you might be watching this on demand now. We have training manuals with lots of different resources and materials, so you don't have to reinvent the wheel. And we have mentors on staff. So if you are getting a case from Children's Law Center as a pro bono lawyer, when you get that case, you'll be assigned a mentor. And it's going to be someone who has expertise in practicing the particular case type practice area. And they'll give you some initial recommendations for getting started on the case and be available to strategize and brainstorm, answer questions throughout the duration of the case. Our virtual training series, we have been covering all of our practice areas with a special session on cultural humility, something that just impacts all of the work that we do. What does it mean to provide culturally humble representation to clients, no matter the case type and practice area? These trainings are available on demand. Again, you might be watching it that way now. And for today's training in part 3, it's closing out special education. So in part 1, we asked the question, what is special education? And we walked through the law and some of the process of just what it means to be handling a special education case. Part 2 was digging into handling a special education case in terms of working with clients, working with the CLC mentor, and then how we are coming into different meetings and areas of the practice and how we work with our clients, some tips for just handling. And today, again, is for due process. So ultimately, our cases are not frequently litigating, but if they do, it's a due process hearing, and you're going to hear from our presenter today about what that means. And we are tacking on some of the remote representation details of what it looks like for special education cases right now. We're handling them remotely, we're working with schools and clients remotely, and we can offer mentoring guidance in addition to training to support you and what that means. If you have questions, you can put them in the chat feature if you're with us live. And if you're watching this on demand, shoot me an email, feel free to reach out. We're here to support you and happy to do. We have resources from presentations and videos to manuals, and you can find them all on the website. So if you go to childrenslawcenter.org, at the bottom of the page, you can click on Pro Bono. It will take you here, and there are links on the right-hand side to go to the resources that I just alluded to. If you're interested in the case, I'm the person to reach out to. We can talk about what might be of interest to you and what might be a good fit so that it's a case that you're feeling comfortable taking on and will be successful for the client you would be serving. In terms of our training, we would love to have feedback in a virtual setting. This is different. We love any particular feedback you might have about participating in this training virtually, watching it on demand, and the content, anything that we're covering and what is effective or what might be more effective. We welcome your feedback. We're going to go into the due process hearing now. I am going to hand it over. I'm going to stop sharing my screen, and you'll see that Jeannie Tillery is back for part 3 of our special education training. She's a supervising attorney at Children's Law Center, and she has been handling these cases for so many years and mentoring pro bono lawyers doing the work. So Jeannie, thank you for taking us through this entire series, and I'm going to hand it over as you close us out for part 3.
Thank you, Jen. I'm going to start sharing my screen now. Okay. Let me get my. Okay, can you see my screen?
Yes.
Okay, great. Okay, so good morning. We're going to start with talking about the due process hearing. So, we've already talked about the process of how you get to, get special education services. And in a due process hearing, before we even get into it, this is what you would use if you say you're trying to get special education services and you're unable to get them. The parent and the school are at an impasse and you can't get the services that the parent wants, or in addition to the child's not receiving a free, appropriate public education. Then if you are at that point, then your next step to try to force the school to do what you want is the due process hearing. So due process hearings, special education cases are litigated initially administratively. So it's kind of like it's an administrative hearing, but it's a trial type administrative hearing. You have independent hearing officers that are contracted to hear petitioner's claims. Petitioner, we are the petitioner when we file these claims. The hearing officers are lawyers. They're not administrative law judges. They are lawyers like you and I that have been selected and contracted with OSSI to hear these claims. The hearing officers are directly in control of their case management. So what kind of things can you file about in a due process hearing or a due process complaint? What can you put in it? Any denial of FAPE against the student by the LEA or the SEA, so the local school district, the local educational agency, or the SEA, state education agency. In DC, the LEA could be DC Public Schools. It could be a charter school. The SEA will always be OSSI as the respondent in the complaint. Alleged violations must have occurred not more than 2 years before the date of the filing, that the party knew or should have known about the alleged action forming the basis for the complaint. So anything past 2 years, there's some statutory and case law exceptions to the statute of limitations, but for the most part, if you're trying to file a due process complaint, the alleged violation, the harm has to have happened in the past 2 years. The other argument, like it says, if they knew, or even if they should have known, like if a child is a 10th grader on the pre-K level in reading and math, and they haven't done anything about it, they should have known that this child was in need of special education services. That's just an example. What remedies are available? So when you file a due process complaint, what would you be asking for? What you're going to ask for as your remedy is any remedy that can address the denial of FAPE. So it could be placement. So if the child is not receiving an appropriate IEP in an appropriate school setting that can serve the child's needs, you might ask for the child to be placed in a special education day school, and you ask for the LEA or the SEA to pay for that placement. For example, if you wanted the child to go to a special education day school, they can run anywhere from $40,000 to $60,000, maybe $70,000 a year, the tuition. And so your remedy would be asking for that to be paid for. You could, and also that they would make sure that that they would be funded there, transported there, and everything that goes along with the private placement at a special education school. You could ask for increased services on the IEP. Say the kid doesn't have counseling services or needs more speech services. Those are things you can ask for as relief. You can ask for additional services, accommodations on the IEP. You can also ask for CompEd, which is retrospective remedy. CompEd is compensatory. We call it CompEd, but it's compensatory education. It's essentially paying kind of like back pay for missed education services. And I'm going to talk a little bit about that in a few slides, but that's another thing that you can ask for, and we typically ask for, in addition to like the prospective remedies listed here, we always usually ask for comp ed. And here's the slide. Compensatory education. So like I said, we call it comp ed for the most part, and this is a term for the remedy for past denials of FAPE. And in DC, compensatory education must place the child where they would have been but for the LEA's failure to provide a FAPE. The key case for comp ed is Reed versus DC. This is a really, it's a case that other jurisdictions refer to often, but it's because it's in DC, obviously, it's binding on our jurisdiction. And I think that one of the things that's the most important about Reed is that it says that, you know, compensatory education has to be qualitative, not quantitative, I think. And and you can't ask for hour for hour. So for hour services. So let's say a kid has 10 hours on their IEP and they miss those 10 hours for each week for a month. Well, you can't then go and say, well, for the comp ed, they missed 10 hours. They should receive 10 hours for each 10 hours they missed. That's not, it has to be based on like what, it has to be, there's more of a formula to it than that. If you ask for it, they missed 10 for 4 weeks, you can't just ask for 40 hours. First of all, in that case, they talk about that, you know, when you're one-on-one tutoring is more intensive than in the classroom. So you're really asking, if you ask, it doesn't equal out. 40 hours in the classroom is not the same as 40 hours of intense tutoring one-to-one. And so that's why it has to be based on quality. There's no exact science for comp ed. Sometimes we use compensatory education experts to help us figure out how many hours are needed. There's a negotiation, can be a negotiation between the school and the parent about how much the child should receive. It's also important to ask the parent how much do they think that the child can take in. For example, I have a case where we had 400 hours of comp ed, and we were thinking about maybe the child needs more than that or less than that, but ultimately it wasn't even practical for the kid to get to have more than that, just because the kid was receiving other services outside of school, was already in a special education day school. And, you know, if the kid is already getting therapy every night, you have to be mindful that, you know, the child is not a machine and is not going to be able to do therapy every night and then also do like 3 hours of comp ed tutoring every night, you know. So you have to be realistic about when you're requesting it and what it should look like. Comp ed can include anything the child needs. I was talking about tutoring because that's the primary thing people ask for with comp ed. Child has missed academic services or is way behind because of school's harm, the school's denial of FAPE, so they need tutoring. So there's independent tutorers that would, you know, help the child get caught up. You can ask for speech and language services if those are the services that were missed, or mental health services, transition services. You can also get a little bit creative with comp ed. Sometimes we've had comp ed be like going to like a reading camp or something like that during the summer. It can also be technology and software. We've had comp ed awards be an iPad or some sort of technology software. It could be something, assistive technology device that could help. Anything that puts the child where they would have been but for the school's denial of FAPE. So when you're handling a case, as we've talked about through part 1 and part 2 and part 3, we talked about the steps. You must keep in mind that as soon as you get your case, you always have to have in the forefront that this case might go to a due process hearing. Things at some point along the way might not work out. So you want to always be thinking about what it looks like, to what information that you would use to file, what documentation you would need. And it's really important because in special education hearings, hearsay is admissible. So, you know, let's say you write letters to the school. I am one that likes to write actual like letters and just like attach them. But a lot of people also send emails. Those are also admissible. So let's say, you know, you've got a case and the school won't hold a meeting, or an IEP meeting, you could just write a letter to the school documenting, like, you were supposed to hold an IEP meeting, you didn't hold an IEP meeting, this is a violation, and please respond. You submit that to the school. Well, if down the road things continue to go poorly with your case and you file a due process complaint, you can use that letter as evidence of, like, their violation. Your letter to the school can be used. So that's one thing that is, I think, really unique to special education cases and really helpful, because it reminds you that you can always just keep, like I write a lot of letters and a lot of emails, and then if I need to file, then I can just go back through and pick and choose what I want to put in that, and my disclosures or my disclosures of evidence. Once you file the complaint, it moves pretty quickly compared to like civil litigation, where you're in court and you may not get a hearing date until the next, like, a year from the date you file or something like that. The case has to be resolved in 75 days. Well, that's not very long. They move pretty fast. If you have an expedited complaint, it's even faster. That's 20 days. There's some rules that go along with when you can file an expedited complaint. You can't always file an expedited complaint. Because it moves so fast, you also want to be careful about filing a expedited complaint, because it could be really burdensome on you as the attorney to put everything together within 20 days, which is not a lot of time. 75 days is also not a lot of time as well. So it's just something to keep in mind. You will have to submit all the documents you will use at the hearing 5 business days before the hearing. So that's what I mean when I said the disclosure evidence. We don't have discovery. The farthest we get into, like, discovery is stopping at, I think, will be disclosures, which is what we call our evidence that we submit. So 5 days before the hearing, you will submit all the documented evidence that you want to use, and you'd also list all the witnesses that you're going to call, and you would submit that information to the hearing officer and also the opposing counsel, so the respondent. You would submit all that. So the letters you wrote, everything, evaluations. Sorry, I thought there was a slide here about that. There's like any letters you have, psychological evaluation, speech evaluations, IEPs, letters from the school, letters to the school, letters from the doctors that have been presented to the school. Any information that you have that you want that will support your case, you would include it in the 5-day disclosures. And if you have, if you take a case where you have a due process complaint and you're filing a due process hearing, please reach out to your mentor for more information about the ins and outs of taking a case to due process hearing. We do mentor mentees, pro bono attorneys in those types of cases, and we want to make sure that you have a successful outcome. So please talk to us further about any questions or concerns and the things that we use to put into place to have a favorable outcome in a due process hearing. So I'm going to switch gears now and talk a little bit about COVID-19 considerations. Special education pro bono cases during COVID-19. Here are some tips for working with clients during COVID-19. Obviously, like everything else in the world right now, we are meeting virtually. You may need to meet with your client and the school virtually, FaceTime, Zoom, Microsoft Teams, Google Meet, all the different platforms that are available now. And you might even just do an old-fashioned phone call to talk to your client. Or the school, you might just, you might have a conference call. But those are things to keep in mind. Schools are still operating virtually, so IEP meetings can still happen virtually. Due process hearings can still happen virtually. If your client has questions about resources available during the pandemic, you can direct them, or you can provide our website that has all our COVID-19 resources. Keep in mind that clients may be less responsive to you due to the increased demands and stressors. You know, Jen and I were just talking about how everyone's mind is kind of divided because there's so much going on. And so you have to keep that in mind. If your client is not as responsive, they don't return your phone call, it could be anything that's going on, and just be mindful of that. So some of the information in the next couple of slides, it's not a definite. Things are changing every day. It's still, you know, uncharted territory with the schools. There isn't any one set thing that's set in stone just yet for DC public schools. Then there's also all the charter schools that operate independently of DC public schools that are finding their way as well, and may not have the same follow the same things or same guidelines that DC public schools are following. So that's something to keep in mind as well. So just going through this slide, is it safe for your client's child to return to school? Things that the parent might want to consider are the medical diagnosis that may make it unsafe for the child to return. Does the child have anxiety or other diagnoses that will make it difficult for the child to return in person? Again, don't know what it's going to be in the fall just yet. If it's going to be hybrid, what's going to happen if parents don't want to send their kids back to school for the simple fact that there's no treatment and there's no vaccine, just out of like sheer fear of sending their kid back to school. I don't know what that's going to mean, but this is just some considerations to think about when thinking about the fall and how special education cases run. One thing I will add is that when it comes to special education cases, IDEA is like the law is still 100% valid. There's the Department of Education didn't allow for any waivers for special education services, which means that, you know, there's nothing in the law that says because of COVID-19, children no longer get special education, or children no longer get IEPs, or they no longer get their IEP services, or any of those things, or you know, inappropriate education. Schools are still required to provide children with special education services under IDEA. So this comes up with the evaluations we're having. This is an issue that's brewing right now, and I'm not quite sure where this will go at this point. But one of the issues is that a lot of, you know, with school evaluations, we've talked about in part 1 or part 2 about how to get evaluations and when they're needed. But then the issue came up of like the schools like, well, we don't want, a lot of schools are saying we can't do evaluations until we return to the brick and mortar school. Well, as time passes, that's seeming that we don't know when that's going to happen. We don't even know if that's going to happen. That might not be for a year now or 6 months from now. So what does a parent do when they need their child to be evaluated? Some of the things that some of us have been asking for is like, some schools are willing to do parts of the evaluation to provide some useful information that they can develop an IEP and determine eligibility. Some schools are saying, no, we won't do anything at all. There are some independent evaluators, psychologists, speech language pathologists that are willing to do virtual evaluations. There are some independent evaluators that are willing to do in-person evaluations. One of the issues when it comes to evaluations is part of the requirement is there has to be an observation. Some people have found it helpful to do an observation just virtually, like kid has an assignment, they're doing distance learning. The evaluator sits in virtually to watch how they do the assignment and does their observation that way, which might actually be a practical way to do it, considering that distance learning is likely going to continue for the long term. That an observation of distance learning does make sense when you're talking about creating services. When you have an IEP meeting to discuss evaluations, consider asking for a prior written notice documenting the LEA's plan for evaluations. The prior written notice is something that is required by IDEA. The prior written notice should say what a school what a IEP team agrees to do or refuses to do and the reasons why. And so when you have an evaluation, if you're discussing evaluations and the school says, no, we won't do them, or we're going to do them at the beginning of the year, they should put that in what it's called a prior written notice to say what they're doing and why they're doing it. If the parent doesn't agree, if your client objects to waiting and wants an independent evaluation, that should be reflected in the prior written notice. It should say, the school, the LEA unilaterally wants to do the evaluation in the fall, but a parent who does not want to do that. It should not say the IEP team, because the parent is a part of the IEP team. So if the parent disagrees with what the school wants to do, the prior written notice should be specific and say that, because you want to keep that in mind. If you end up filing a due process complaint down the road, and you want to use that document, it will look as if your parent agreed when they didn't. Specialized instruction and related services. So some more considerations. Does your client's child have access to a device to access virtual instruction? If they don't, does your client want to contact the LEA to request one? They probably want to notify the school that they don't have access, they're going to do something with attendance and how they're tracking attendance through virtual instruction. So you want to make sure that the parent has reached out to the school to clarify what they have and what they don't have to access their education. What does your client's child's school schedule look like? You want to make sure that the parent knows what the child is supposed to be doing each day, how many hours each day they're supposed to be doing that, and then is the child receiving all the services on their IEP? If they're not, does your client want to advocate for increased services? Does your client want to have a IEP meeting to discuss the child's distance learning and what it looks like? These are things to consider. You want to, I would say, talk to your mentor further about IEP changes, decrease or increase in services, because that may have an effect down the road. If you reduce, let's say, for example, you reduce services because the child is at home, well, does that could trigger the school to think, well, the child doesn't need as much services. You reduce them when really they really needed to keep their IEP the same, and the school needed to accommodate the child's needs. So just considerations to think about. And that's all I have. If you have any questions, that's the end of my presentation. Obviously, you can email Jen here, and I'm going to stop sharing my screen and turn it back over to Jen.
Thank you so much, Jenny, for that. Appreciate it. And at this time, that does conclude part 3 of our Special Education Pro Bono training series. We'll have everything available on demand if you're with us live, and if you're watching on demand, please don't hesitate to send along any questions. We do have a survey available for feedback. You can just contact me directly. We can discuss any cases or questions that you have about taking on a case with us and just what the logistics and nuts and bolts of that look like. We're more than happy to discuss it with you. So thanks again for joining part 3 of our Special Education Pro Bono training.